And welcome everybody to the Law News Network. I'm your host, Rachel Stockman, also editor-in-chief of LawNewz.com. I'll be with you for the next hour and a half or so. We are getting a break in the Frank Bybee trial, a trial that we've been following out of Florida, a really crazy trial. The defense rested just a few minutes ago, and we are getting word that the state is deciding if they want a rebuttal witness. It sounds like they're going to have one witness after lunch, and then we're getting jury instructions. So that means this case is almost at its conclusion. Likely we'll hear those closing arguments tomorrow, and then this case goes to deliberations and is in the hands of the jury. I am joined now by Stephen Mulroy. He's a former federal prosecutor and now currently a professor in Tennessee. Stephen, are you there with me?
Yes, I'm here at the University of Memphis. Hello.
Yes, the University of Memphis. Thanks so much for joining us. Okay, so here we are. State has rested. The defense has rested. We're at the final legs of this trial here. What's your impression? Has the prosecution made a strong enough case, and did the defense do a good job at chipping away at their claims?
Well, it's an interesting question. It's obviously going to be ultimately for the jury to decide. I mean, there does seem some relatively damning testimony by the prosecution about the kind of abuse that she suffered, and the payments that were made to him. It seems like they painted a case that he was possibly taking advantage of her. Now, he's tried to the defendant has tried to suggest that the woman is basically demented and self-destructive, and that she's making all of this up. I guess really what works in his favor is that he only has to create reasonable doubt, and as long as there is one reasonable doubt in the mind of one juror, then that might be an acquittal.
Well, and let's talk about some of the evidence here, because at the end of a case, I always like to keep a list of what the prosecution has, because this isn't a slam dunk case. You had the victim, Marcia Soul, testify. She was the first witness called by the prosecution. Normally, that would be a pretty strong thing for the prosecution to have the victim testify to what happened. But in this case, there's some concerns about what the victim says and whether she's truthful.
Right. And, any time that you've got anything at all that damages the credibility of a prosecution witness, that can be obviously bad for the prosecution. It doesn't necessarily have to even be material to the main allegations of the case. Anything that suggests a lack of credibility on any matter on the part of a prosecution witness can undermine the case, because, as we said before, it requires only one reasonable doubt in the mind of one juror.
Okay, so just to review in my head some of the damning details for former Deputy Bybee. And again, this is the case out of Florida that we've been following, where this deputy allegedly kind of befriended a woman he met while he was on the police detail, got entangled into her life, got involved in her finances allegedly. And then one day, January 12th, he's alleged to have gone over there, tried to stuff pills down her throat, and then left her car running in the garage with the door open to try to poison her with carbon monoxide. That's the allegation. And of course, the whole time she was complaining about this guy. But prior to this incident, there was kind of an internal investigation going on. But in terms of evidence linking him, we have her story. We have the fact that his home surveillance. So, Steve, he had a home surveillance system. I don't know if you heard this testimony.
I didn't hear this part, no.
He had a home surveillance system. And on I think it was the night before and on the day, so within the 24-hour period when this alleged crime occurred, miraculously, somehow, the video wasn't working. And the investigator testified that every other day it seemed to be recorded. But that one day, some reason isn't there.
Well, that is suspicious. And didn't he also borrow somebody else's vehicle on the day of the alleged assault?
Yes. So the day, right, that black car, he had a friend testify he asked to borrow it. There's neighbors that saw the black car in her driveway. So
And the reason he gave for borrowing the car was somewhat suspect, correct? He claimed that he was doing some sort of undercover investigation that wasn't corroborated.
I actually don't know that detail. Kathy's listening in, our trial producer, but I think that sounds accurate, that he gave some kind of excuse for it. His wife, Steve, took the stand on behalf of the prosecution, which is kind of unusual because we can get a little bit into this. I'm not sure how the laws work in Florida, but she basically couldn't really confirm he was home the night of this alleged incident. Now, I know you could probably talk to Tennessee, but usually the prosecution can't call a wife to testify against their husband. Are there exceptions to that in many states?
Well, yes, and one of the exceptions is if in many cases, if the wife chooses to testify. In most states, the law is you can't compel a spouse to testify against another spouse because of the marital privilege. There are some exceptions to the marital privilege if any of it occurred outside, before or after the marriage, for example. But in many states, I think Florida must be one of them, that's a waivable privilege. And if one of the spouses does voluntarily wish to testify, then that is acceptable.
Can you ever force a spouse to testify? Are there any situations where a prosecutor could get around that?
Uh, there are some exceptions. I don't think they apply, from what I understand, in this particular case.
Okay. All right. So we're going kind of through some of the evidence. We have this surveillance. We have the wife testifying. We have, okay, here's another detail. The blue gloves. So the victim, alleged victim, testified that that Frank, Deputy Bybee, was wearing blue gloves when he entered her home. They had another investigator take the stand in kind of a dramatic display for the jurors. I don't know if we have that picture, if we could get it up quickly enough, but they brought boxes and boxes of blue gloves that they had found in his house. See, that's what gets me. Steve, was tending to think, okay, maybe this woman is making up the he killed her part, and yeah, he did get involved in her finances, but maybe she is a little crazy. She did try to commit suicide in the past. Maybe she's making that up. But the blue glove detail, that seems like something the jurors can hang their hat on.
Well, I think, Rachel, it's a steady accumulation of things. I think you're right. The blue glove detail, the black vehicle detail, the suspicious absence of home surveillance video for that 24-hour period and that one alone. And perhaps most, I think, corroborative of all of the woman's story is the fact that there had been a consistent series of complaints about abusive behavior by him. She didn't just, come up with this at the last minute. So that if there's a consistent pattern of complaints and some circumstantial corroboration, like the blue gloves and the black vehicle and the absence of the home video and the suspicious nature of why he had to borrow the car on that day, I think that might be enough to corroborate the woman's story, and you do have her story as well.
Let me ask you this question. So if you were to, I know you were a former federal prosecutor, so you're pro-prosecution. Well, I don't know if that's true, but
I've also done some defense cases as well, and
okay.
I teach in the area, so hopefully I have some sort of objective viewpoint.
Okay, so here's the question, and one of our other analysts that was on earlier mentioned this, and she's a defense attorney. She said, if the man wanted to kill this woman, she's 79 years old. You saw her on the stand. Maybe we can throw up some video of her on the stand. She's like a pretty frail looking woman. Why didn't he just kill her?
Well, it's a fair point, and it's one that I wondered when I first started to read press accounts of this case, because there's a gap. According to the woman's story, he was forcing pills down her and tried to smother her with a pillow, but the button on the pillow allowed some airspace, and then she blacked out and he was gone. There is a natural question there. Well, if she did black out, then why wasn't he able to finish the job?
Right, like you can see her there on the screen. She's in a wheelchair. She's very frail.
You'd have to assume that he had some sort of change of heart, that, after the ordeal of struggling with her and not being able to finish her off, he panicked or had a change of heart and then just left. I can see how the defense counsel might say that that seems to be a suspicious tale, and maybe it's enough to lead to reasonable doubt. I mean, obviously that's what we have jurors for.
Absolutely, but that is a lingering question. And then, if he is a deputy, right, when this happened,
Right.
it seems like he would have known a better way to kill someone than to try to force pills down their throat. I mean, I can't imagine that's the most effective way to try to get someone to swallow pills.
Well, yeah, I mean, I don't know if he could have, mixed them into something and
Right.
given it to her unknowingly. I don't know. I mean, obviously, the idea of the pill supposedly is that it would make it look like it was an accidental overdose or something,
Or
as
purposeful if
opposed
she
to.
wanted to commit suicide.
Right, right. I will mention one other thing, Rachel, is that this is not maybe directly relevant to this criminal case, but the problem of elder abuse, the kind of
Yes.
elder abuse that's being alleged in this case, is actually unfortunately rampant in this country. And there have been a lot of task forces and studies done to show that it's becoming increasingly common as our population gets older. And in fact, Florida in particular drew upon some of the work of one of my colleagues here at the University of Memphis and adopted a statute to protect elder people from elder abuse, which presumes elder fraud in certain cases where certain criteria are met. Now, that mostly takes place in the civil context about, getting their assets back and that kind of thing. But I think it does provide some background here that, this case plays out against a backdrop of really an epidemic, or at least a rising number of elder abuse cases.
Absolutely, and as baby boomers continue to age, and there's such a big population now that are getting into that age group where they're vulnerable to be taken advantage of, it's going to
Right.
become more and more of an issue.
Right.
Most of the cases, and you would agree probably, Steve, that we see have to do with guardianship and issues with finances. I mean, it rarely gets to the level alleged, thank God, in this case.
No, I think you're right. I mean, this is an outlier, certainly. I mean, we don't know if there was elder abuse. It could be that the defendant's account is correct, but if the prosecution's count is correct, this is a case of elder abuse gone way over the line. Tragic. Where I guess the theory is the elder abuse took place in terms of pilfering money from her, and then eventually he realized that he might be discovered and decided that killing her was the way to silence her.
Well, and if
As
you
you say, that's rare, and thank God it is rare.
And if you think about it, Steve, in many ways, she's kind of the perfect victim for this because, not only is she an older woman, she has a history of some mental illness. She had been rejected, according to testimony we heard, from 2 or 3 other rehab senior living facilities because of her behavior. So I think that he was really able to convince many of his other officers that going into this, okay, this lady's just crazy for some reason. She has it out for me.
Right. No, I think you're right, and it's difficult to know what to do with these facts. I don't envy the juror's task here.
Yeah. What do you think? Now, let me ask you this question. We're getting into closing arguments tomorrow. They're supposed to start. How do you think, and I believe closing arguments are really critical in a trial because they finally try to, put everything in a package and paint the full picture
Right.
for the jurors.
Right.
What do you think the defense has to do in order to create some reasonable doubt here? They've picked away at it, but do you think there's enough of a package where they can get a home run here?
Well, possibly. I mean, you've already indicated that there was some reason to question the credibility of some of the one of the prosecution witnesses, and there's certainly enough in the victim's background to suggest that she might have mental problems and might have a motivation to fake this. I think perhaps maybe the most persuasive point is the one that you mentioned earlier that was articulated by one of your guests who is a defense counsel, which is if his intent really was to kill her, then he certainly could have done it. Why was he not successful given the disparity in size between the victim and defendant? I guess a skilled defense advocate can tie all these things together and weave a story that would suggest reasonable doubt. It doesn't take much for reasonable doubt in our criminal justice system. I guess it's going to be something interesting to see. I mean, really, maybe one of these cases where it comes down to the advocacy skill of the respective lawyers.
Let me ask you this, because I know you study some of this area in the criminal justice system. As we become more of a world of CSI and all these TV shows that somehow always are able to get this minutia fingerprint evidence off of everything and connect all the details. Once again, this is really a case that's somewhat circumstantial, or maybe not entirely circumstantial, but you don't have that smoking gun of a fingerprint on her neck, so to speak. Linking Frank Bybee to this actual attempted murder scene. Do you think that that's something that jurors really like to see nowadays?
Well, Rachel, you're probably already aware of this, but for many years now, prosecutors and judges and commentators have been referring to something called the CSI effect. And the idea here is that after watching so many years of police procedural television, which exactly have the kind of spot-on DNA evidence and other types of forensic evidence that you described, jurors now expect that in all cases. And the reality is, as you probably know, that it's very unusual to have that kind of evidence in cases. You know, you can touch something and not leave fingerprints. You can be in a room and they don't retrieve relevant DNA samples. And so the absence of that evidence isn't necessarily damning to the prosecution, although it might be in the minds of 21st century jurors. And that's something that's a challenge that prosecutors have nowadays.
Well, it's interesting, too, because you wonder, years ago when there wasn't an assumption that prosecutors would bring that evidence, if perhaps jurors were more likely to convict based on circumstantial evidence. I don't know if there's been any kind of empirical study on that, but that would certainly be interesting.
Well, I do know this, that the pattern jury instructions in most jurisdictions have a standard jury instruction describing the difference between circumstantial evidence and direct evidence. But they do that then, so they follow up by saying there is no difference in the law between circumstantial and direct evidence. It's not necessarily that you're supposed to give more weight to one or to another. The idea here is that it's possible to convict solely on circumstantial evidence, and the absence of direct evidence need not be fatal to the prosecution's case. I mean, when you think about it, it's not necessarily the majority of cases where you have eyewitness testimony or DNA evidence that, you know, proves almost conclusively that the person that they accused was the person who was present at the scene. But nonetheless, we got along for centuries, you know, before DNA evidence was managed to have a criminal justice system.
Very interesting topic, too, because it's one of these things that affects all of our cases, because a lot of times the cases that end up going to trial are the ones that don't have that direct physical evidence linking someone to the scene, because obviously if a defense attorney knows that cops have that, they're more likely to come to some kind of deal with the prosecution. So it's really these cases that we've been following on LawNewz that rely on a bit more circumstantial evidence that end up going to trial.
Well, you're absolutely right about that. And in the entire criminal justice system, 90% or more of all cases do resolve by pleas. I mean, it's much higher than that. In the federal system, it's over 95, sometimes 97%. It varies from states, but it's always usually in the range of 90 to 95% of cases settling through pleas. So it's only the most difficult of the cases, as you correctly pointed out, that go to trial to begin with.
Steve, will you stick around with us for a few more minutes, because I want to replay and I want to have you comment on this, if you would. Some testimony from a neighbor of Marcia Soul, the victim in this case. She testified yesterday. She was a defense witness, and she talked about what a grouchy, kind of awful person her neighbor was, and then she talked particularly about the injuries that Marcia Soul allegedly had the morning of the alleged attack. So let's play those clips if we can, and then Steve, if you can stick around for a few more minutes, that would be great.
Sure.
And we can ask you about that.
Very good.
Did you, as a result of being listed as Ms. Soul's healthcare advocate, did you have to sign any paperwork?
No.
Were you provided any documentation by Ms. Soul that designated you as that
No.
individual?
No.
As a result of that designation, did you have conversations with Ms. Soul's medical provider?
I did with her, the liaison down at the Pines in Punta Gorda.
Did you ever speak to anyone from Dr. Lerner's office?
I spoke to Dr. Lerner.
All right. How many times?
Once, I think. I'm not sure.
Did you ever visit Ms. Soul in any facilities?
Yes, she was at Health South, I think was the name of it, Health South. It was on,
Is that the only place that you visited her?
yes, because I took her clothes.
Was that on her request?
Yes.
Could you describe for us how you would have taken clothes to her? In other words, did you go buy them or go get them?
No, we were on a cell phone together, and she had me go through each thing one by one, and I packed everything up and took it to her.
Go through each thing one by one.
Well, socks.
Were you in her home?
Yes, I was in her home. I was in her dresser.
How did you get into her home if she wasn't there?
I had keys at that point.
Were you given permission to
Yes.
go?
She said, please go in. And I said, I've got a suitcase. I had a duffel bag. And she had me go through checkbook, papers, credit cards.
Did you bring those items to her?
Whatever she wanted, I took to her.
How many times do you think you did that?
Well, that's the one time I remember doing a
Yes, ma'am.
very thorough job, yes.
I may have one moment. Mulroy, when you arrived that morning, did you see blood everywhere on the floor?
The morning of
January
the 12th.
2017, when you said you got there,
No.
did you see blood on her chair?
No. I saw one dot on her nightgown, and her chair was a mess, and there was stuff all over the floor. Oh, okay.
Listen to the question, just answer the question, okay?
When you say chair was a mess, what describe that?
Well, there were, looked like she dropped her pills on the floor, and she had Kleenex all over the place. There was, I think, some water, I think Kleenex.
Anything else?
I don't remember. I've got a picture.
I understand.
Okay.
Did it appear to you, from what you saw, Ms. Dunbar, that Ms. Soul had been
Objection calls for speculation.
her observations?
You can ask her about her observations, but you're asking her to render an opinion about, based on those observations at this point, so I'll sustain that objection.
Based on your observations, based on what you saw
Okay.
of Ms. Soul,
Yeah.
what was your impression?
Impre-
Objection.
Overruled.
Objection.
Okay.
Go ahead.
Can answer.
Can I answer this?
Yes, ma'am.
Okay, I assumed,
No,
and I,
don't assume.
Objection.
oh, can't say so.
Just what you observed.
I thought she probably,
Objection.
Ma'am, if you are assuming or thinking to yourself this may or may not have happened, then it's not proper for you to give that opinion, all right? Because you're assuming or you're thinking that this might have happened or that might have happened.
okay,
So it's only when you can give an opinion based on facts that you're able to give an opinion. Doesn't sound to me as though you get all the facts to
No.
give an opinion.
no, I can't give an, no.
Fair enough. The
Probably. Okay.
You told us that when you took these pictures from Mulroy, that you just had one little spot of blood on the next one.
Yeah. That's what I see here is the spot right here.
You only see one spot of blood
Mhm.
on the next one.
Yeah.
Okay, would you like to turn around and look at the picture behind you? Still only see one spot of blood on the next one?
Well, it's enhanced.
Do you see only one spot of blood on the next one?
Yeah, right here. Okay.
That states exhibit 4A, which is what you took. Turn the next one. And when you look at the picture behind you,
Mm-hmm.
are you telling us that this picture does not reflect any injuries? This is
Yes.
you're telling us
I mean, I see, yes.
you see what?
I see some injury.
You see some injuries,
Yes.
and yet you testified that she had no injuries to her face.
I thought she hit her head on the tub.
You're not speaking, and please don't tell us what you thought.
Okay.
Does this photograph, this exhibit 4B that you took 5:30 or 6 o'clock in the morning, show injuries to Miss Sills' face?
Yes.
You're aware, aren't you, that carbon monoxide is odorless?
Yes. I am.
Now, you told us that the car was running when you got to Miss Souls
Yes.
at 5:30, and that you turned it off?
Yes.
You also testified that the garage door was open.
Open.
Can you tell us which garage door it was that was open? Was it the door that from the kitchen to the garage, or the sliding?
Up.
Yeah,
The
up
great
door.
big
Okay.
door was
Thank you.
open
All right.
and the light was on.
Defense counsel asked you whether or not you shared your opinions about Miss Soul with the first responders, the deputies that were there that morning.
Yes.
Okay. Why did you feel that it was important for you to do that?
Because I had had so many talks with her about her committing suicide.
So, did you run home, and I think that's the word that you ran home, to
Well, that's not quite true. I got in my car and went home.
Okay, so you drove home.
I drove home.
And I'm showing you State's Exhibit 16A. Take a look at that for me, please. Do you recognize that?
This was an email.
Do you recognize it, ma'am?
Yes, I do.
How do you recognize it?
Because it was sent to my email address.
Is that the email that you showed to the deputies that were out there?
I believe it is. I believe it is.
Do you have any doubt in your mind that is the email that you showed to the deputies who were out there?
Right now, no.
Right now, no. Why?
Your Honor, I believe she's answered.
I'm not sure. I need some clarification on what her answer was. So.
Would you like an opportunity to read that? Would it help to refresh your recollection? Yes. Ma'am, would it help to refresh your recollection? You have to speak up nice and loud so the reporter can get your answer.
The record will reflect that Ms. Dombrow appears to be reading the email at this time, so we'll give her a few minutes to be able to do that.
I don't remember this at all. This one.
You don't remember that?
No, I do not.
Showing you states 16B.
This, yes, I remember well.
Did you show that to the deputies?
Yes, I did.
Why did you show that to the deputies?
Your
Be-
Honor, instead of standing next to the witness,
Because I thought they had a right to know.
And you actually told the deputies not to take her seriously. Isn't that true?
I might have used those words. I'm not sure right now. It was a long time ago.
Well, can you tell us what you told them about Marcia Soul so that you could influence them not to take her seriously?
objection. That's not what she said.
Rephrase, please. further.
Yes. What did you tell the deputies in order to influence them?
Same question.
I'll sustain the objection.
Yes, Your Honor.
What did you tell the deputies?
What did you tell the deputies about Miss Soul?
That she had been killing herself for years.
You told them more than that, did you not?
Yes, I did.
Please tell us what else you told the deputies.
It's not hearsay if I tell you?
Ma'am,
Okay.
It's okay, ma'am. I'll let you do it.
Okay. Well, I told them I thought she hit her head on the tub because that's where her walker was. No, wrong.
I'm asking you.
Stop.
Wait, okay. What do you want me to tell you, and I'll tell you.
Your Honor, she was in mid-answer.
She was. But you objected. So
Oh, no, I didn't. I objected because she was cut off and wasn't able to finish her answer.
Sorry. Ma'am, you can finish your answer and go ahead and do that.
Okay, I went and I got Marcia's walker, and I put it by her, and I said, how did you get to your chair? And she says, I walked.
I didn't ask you
Okay,
what you said to Marcia.
okay, what,
I'm asking you the opinions that you shared about Marcia and her personality with the deputies there.
I just told them what I thought. They're the professionals, I was
Ma'am,
not. Yes,
I asked you.
Judge, can she finish her answer?
Well, she's not really finishing it, so listen to the question and see if you can answer it solely to that question, okay?
okay.
What opinions about Marcia Soul's personality did you share with the deputies that morning?
The fact that she was always going to kill herself.
What other opinions did you share about Marcia Soul's personality to the deputies out there?
That she had been in a couple of psych wards.
Did you also say, "Good luck, boys, she is nasty"?
I don't know if I said good luck, boys.
Is
Even
there
though
any-
they're young enough to be my sons, I probably said she is nasty and she's a piece of work.
Thank you. Were there any other opinions that you shared with the deputies?
I don't remember right now.
Thank you. Nothing further.
Thank you.
Redirect.
Only, man.
79.
And during the time period that you have known and associated with Miss Soul, have you known her to use foul language?
Constantly.
The email that you shared with law enforcement,
Right.
was that email consistent with how Miss Soul?
Talked? Yes.
Your Honor, objection. She said she didn't recognize it.
She said she recognized 16B. If that's the one she's referring to, I'm not sure.
I'll clarify.
Okay.
Let's make sure that we're talking about the same
Yes.
email.
Email
Okay.
you have in front of you,
Yes.
which is 16B as in boy. Is that email consistent with what you know Miss Soul to be? Or talk
Exact words, almost.
The photographs that Ms. Fravelin showed you, 4B and 4A, you indicate that you see, now that it's blown up, some level of injury.
Yes.
Are they the same that you saw with photographs 5A through 5E?
No.
Thank you. May I retrieve you?
You may.
I have no further questions.
Thank you. Any subject to recall?
No.
All right, thank you. Ms. Stambro, completed your testimony. You're free from your subpoena at this time. You can go home and go about your business.
Thank you.
You're welcome.
And have a vodka.
Next witness.
Yes, we would call Sergeant.
And welcome back, everybody, to the Law News Network. I'm joined by my guest, Steve Mulroy, who is reporting from us out of Tennessee. Thanks so much for joining us, former federal prosecutor and professor at Memphis. Tell us your take of this witness. Defense witness called to the stand, obviously is not a big fan of her neighbor, who is also the alleged victim, Marcia. What do you take of her testimony? What do you take from it?
Well, I mean, I only got to see a few minutes, but the overall demeanor seems credible. I mean, it didn't seem like she was obviously lying in one direction or another, was struggling to do her best to answer the questions as best as she understood them and to obey all directions. I thought on the substance of it that it was particularly interesting that she had said that she had repeatedly and for the longest time threatened suicide, which is consistent with the defense's argument that the injuries were self-inflicted, and that, she had been in a mental institution previously, and according to the witness, that she was often acting crazy or saying crazy things. All of this corroborates the defense theory that she was a person not to be believed.
But what do you make of this testimony? I think you heard a little bit of it, where she basically said when she was called to the scene, the neighbor, when she went to go visit her neighbor, Marcia Soul, she didn't observe the same kind of injuries that she was later shown in the state's photos that were taken of Marcia Soul.
I don't know what to make of it. It's odd because if the theory is that the state's photos had been later doctored, then that would suggest that the state officials were involved in an attempt to frame the defendant. And that strikes me as a bit more of a stretch as a defense theory than simply a theory that says that the victim acting alone had concocted the story or convinced herself that the story was real.
Well, and you know, they had a firefighter, paramedic guy take the stand, the defense did too, earlier today, and he also testified to the same thing, that basically the injuries did not seem so bad when he arrived on the scene. So I have a couple of questions about this. I don't quite understand, A, first of all, what they're trying to prove by saying that, and B, you know, anyone that knows an older person knows how easily older people bruise, so it wouldn't be that surprising that after a couple of hours the injuries would seem to be more severe, that there would be more bruising. So, you know, the defense keeps harping on this. Well, the pictures look different. You know, the firefighter, paramedic guy saying she didn't look the same. The neighbor saying she didn't look the same. But what does it prove? Are they trying to say in between that time period she somehow went into the bathroom and like hit herself and made these injuries? I don't know.
It's difficult for me to know either, Rachel, but I think you raise a good point. It's not uncommon, especially in older people, for bruises to appear hours after the injury, and so that, you know, the skin looks more damaged hours later than it did shortly after the time of the assault or the injury or whatever. So I think that's an excellent point. I don't quite know what to make of it. You know, maybe the defense is just trying to make every argument it can for reasonable doubt. I don't know.
Excellent. And we heard a new detail that I'll mention too, because I didn't actually catch it, but when that neighbor that you just heard from left the stand and the judge said you can be dismissed, she said, and go have a vodka too. So obviously she said that in front of the jurors. So obviously, you know, she was pretty tense about this testimony. But it's kind of interesting to hear those little moments that happen in court too, because
Yes,
of course
yes.
all of this plays into how the jurors view witnesses and whether they're credible or not.
Right.
Well,
Right.
well, Steve, I really appreciate you joining us here on the LawNewz Network. You're a frequent guest, and we always appreciate your sage wisdom about our criminal justice system. So thanks again, and I hope you can join us again for another case.
Thanks for having me, and goodbye from the University of Memphis.
Thanks so much.